So I would now like to call upon our second discussant, Mr. Pheroze Nowrojee. He holds a Bachelor of Arts, a BA from Bombay University, and a Master's of Law from Yale University. He's also a barrister of Lincoln Inn. He has been a lecturer of law at the University of Dar es Salaam, University of Nairobi, and the Kenya School of Law, where he was also the editor of the Eastern African Law Review. Mr. Pheroze Nowrojee is currently a senior counsel and advocate of the Court of Kenya. Is it High Court of Kenya? High Court of Kenya, Tanzania, and Zanzibar. He has won several awards, including the International Bar Association Bernard Simmons Human Rights Prize. He also has won the Roll of Honor of the Law Society of Kenya and the Pravasi Bharatiya Saman Award of the Republic of India, to name but a few. He has published numerous articles on law, history, politics, and also poetry. He is the author of Pio Gama Pinto, Patriot for Social Justice, and is also the chair of the Asian African Heritage Trust, and has been the board of several human rights organizations. In 1995, he received the International Commission of Jurists Year Award. Mr. Pheroze Nowrojee has been in the forefront in the second liberation of Kenya and has always played an active role in defending the rule of law in Kenya. Welcome, Brother Pheroze Nowrojee.
Coming as the second discussant, there is a different aspect that I touch on, and that is what we miss in Ali Mazrui's writing in respect of constitutions. The background of the early articles, that is the Makerere articles, were the constitutions of post-1960 Africa and African states. And in those, the major constitutional events bringing in constitutions to write and to discuss were firstly Obote I's supplanting 1966 constitution after the coup there, not the Idi Amin coup, Obote's coup. The interim constitution after the union between Tanganyika and Zanzibar, and then the new 1964 Republican Constitution in Kenya. In contrast to a lot that he was writing on, we do not find a consideration of the changes that are made by these documents. Rather, it may be explained by the fact that Mazrui's concentration was on the personalities operating these constitutions, and so there is much in his debates covers Obote, and then a lot in his writings on Nyerere, a little less on Kenyatta, but that was where the focus was, as opposed to the changes in state governance. We can also explain this focus by the fact that Mazrui's judgment on these leaders was not based on their fidelity to their constitutions. Rather, it was on their fidelity, or lack of it, to their ideologies, their personal ideologies. It may have been that Mazrui considered also that adherence or not to the constitutions was not a true indicator of the political health of the countries, any of these territories, and therefore not a fit subject for special interrogation. This does not mean that Mazrui was not interested or was not keeping an eye on the failure of these constitutions in East Africa. But as he departed from these shows on a longer-term basis, he condemned these failing constitutions and these failing leaders by his absence from them, and not by the intense polemics which he could use so well. And also intense debate rather than intense political activism had always been his chosen medium of choice. Once he was more substantially abroad, the flow of articles continued, but they did not always reach us here in any serious sense, because this period, when he moved abroad, coincided with a huge swing in East Africa to anti-intellectualism and the collapse of public discourse, of ideas, and we can understand Ali Mazrui's withdrawal from a participation in nothing. In contrast, for example, to the period from 1962, when he was the initiator and a major participant in public discourse on everything. And this was the time of transition in Kampala, but transition was not just a Ugandan journal. Transition was an East African phenomena and later a continental phenomena. And of course, Mazrui's articles were hugely awaited. We would wait to the end of the month, coming, to see what the response was of whoever was the subject of his previous article, or what his reply was to the reply of the unfortunate insect under the microscope there. So that this was no longer the East Africa that he had known and had been a vibrant part of. It is nonetheless something we miss, because it was important that in the critical years, and I speak of Kenya, 1989 to 1982, when there was when it culminated in the previous 10 years of activity towards breaking the one-party state. In the years from 2001 to 2004, when the practical commencement of constitutional review took place, and then finally in 2008 to 2010, when the 2010 Constitution finally came into being. And this constitutional reform and these periods when it was at its peak, it was important that voices of Kenyans from everywhere would speak, and especially one so exceedingly well qualified, as Professor Ghai has said, that there was no bar to Ali Mazrui's command, not just of the English language or any language, Swahili and so on, but his command of various disciplines. And so that it was a voice that was sorely missed in these critical periods. He did not, for example, he could not, for example, be found in the pages of the Nairobi Law Monthly, or of Society, or of Finance, which were the three major key periodicals during the struggle to end the one-party state and get constitutional reform. Professor Ghai has told us that Ali Mazrui's focus was on constitutionalism as opposed to the provisions of the changing constitutions through the region. But it is important to remember that, as Professor Okoth Ogendo said, to have constitutions without constitutionalism is really a failure. And so too, to have constitutionalism without the thrust to bring in constitutions that reflected this is also an omission. During this period, the writing of Ali Mazrui in the period from 1973 to 2003, let us say, because after that, Ali Mazrui comes back as J.K. Quat, Chancellor, and so on in this period. But in these past 30 years, before that, Mazrui wrote prolifically, as always, about Africa, about self-determination on the continent, human rights, military governments, history, violence, and yet not enough on constitutions. And also, we miss, therefore, the lovely ironies that always peppered his writings. And what would he not have made? What about expecting him to write something about constitutions as the written words of oral communities? Or what about the Constitution as the instrument of anti-colonial success, and the same instrument as the same Constitution as the instrument of post-independence failure? These are little ironies that always, I think, he indulged in himself, but also they were they afforded tremendous sparkle to the profound things that he was writing. So in this approach, broad approach, it is also surprising that when he is looking at the famous triple heritage, that he does not concentrate upon one of the most important and really iconic aspects of the Western part of his and Africa's triple heritage, which was the rule of law. Was he considering that his energies would go into inventing an indigenous form that led to his inclusion of the military in various aspects of government, so that he was looking at the things that Yash has spoken about? Was he in denial of this overriding yardstick by which nation after nation in Africa kept failing? So he was an experienced and an acknowledged and a good manager of academic institutions. He knew the value of and the need for written rules and systems of governance. But he gave little attention to national rules for national governance. And he left that to the contending forces in politics on the ground, while he was looking at the horizons to extend those very horizons in a way that could succeed. But whatever the busy writing that kept him, we miss his writing on this, and we miss him as always. Thank you.